slightly more sort of a contentious one, which has come through. I would say it's political, but the question is, will British industry welcome the bribery bill, given that in the past they could bribe their way around the world without fear of any sanctions from UK government or HM government?
Well, I mean, of course, this is all coming about in the greatest recession this century or since the Second World War. So the cost of business in bringing in adequate checks and controls is going to be relatively high, and it's therefore not going to be something that's welcomed. However, it is coming, and it is something that business is going to have to deal with effectively because of the risks associated with it. So, yes, I don't think it's particularly welcomed. I'm not sure I agree with the second part necessarily of the question. But obviously the UK authorities have been under intense pressure by other authorities, such as other jurisdictions, such as the United States, who have had their house in order for some time and have obviously been acting like the world policeman in corruption issues, using the FCPA. They're keen on British business being at the same disadvantages as American business or other Western jurisdictions.
Right. So you foresee there will be actions both against corporates, individuals?
I would expect that shortly after the bill comes into force, that the SFO probably will want to announce some form of investigation under it. How quickly they can get good headlines in relation to it depends, but of course we see this linking very nicely with Richard Alderman's new self-reporting policy that I briefly mentioned in the talk. So who knows? I mean, we could see a civil recovery order against the corporates and then criminal offences against individuals under the new bribery bill. We could see them really targeting a particular company that quite clearly has got management culpability in relation to the corruption. But I'm sure what they would be looking for is good headlines to really sell the message that Richard Alderman has been selling recently, which is that it is the responsibility of corporates to have their house in order and to have the right systems and controls in place. And then they can come forward when they discover problems and cooperate fully and deal with it nice and quickly and more cheaply. And if you think about Balfour Beatty dealt with it relatively quickly, relatively painlessly, and their legal and accountancy fees are going to be a lot less than those reputedly coming out of the BAE case or Aon, who would have had to budget significant sums to deal with those investigations.
Yeah, and that's interesting because there is a question over the level of the fines you mentioned for Balfour Beatty and Aon. I mean, the Aon fine, I know it's a record for the FSA on financial crime, so that's setting a sort of marker, if you like, but it's still pretty low in relation to the volume of business they're doing in that sort of area of market. I think Margaret Cole said fines are going up, hasn't she? But,
yes, and I imagine that there would be a desire to attach fines to sort of profit made by a business in a period, much like occurs in the competition field. Because if you suddenly saw businesses being targeted with a £50 million fine, for example, that's going to sell a different message than if it's a £5 million fine. Significantly, though, it's not a let-off because, as I say, if you add to the 5 million the costs to them, the PR costs as well, certainly something I think that large organisations or small would want to avoid.
And it's interesting, those sort of costs, I'm no accountant or lawyer, I hasten to add, but those sort of costs wouldn't have to be revealed and enunciated and spelt out in the accounts in UK accounting, I think, in the same way as maybe they would in the States. So I understand
under the Foreign Corrupt Practices Act, you've got a books and records provision, which is very important to maintain and to follow because they're nasty criminal sanctions if you don't. But the bribery bill doesn't create that onus at all.
Okay, so you don't have that. Okay.
No.
And coming back to this point, the distinction between, you mentioned between the Foreign Corrupt Practices Act, which allows sort of grease or facilitation payments, small ones, but the UK, we still are maintaining this sort of straight, clear line, bright line that says, no, not even the smallest payment in theory is no de minimis.
Unless there's a legal obligation to do so within that jurisdiction. So it means technically if you've got a load of bananas stuck in a port in Nigeria and you're required to pay $1,000 to have them released, otherwise they'll go off, that would potentially could be seen as a corrupt payment. But of course, it's so unlikely to be investigated and prosecuted, even if you had a whistleblower come forward and say it. But again, if you had your systems and controls in place, you could investigate it and deal with it accordingly. But facilitation payments remain illegal. It's doubtful that small payments will be investigated and prosecuted, though.
Okay, that's interesting. I was thinking a broader point is clearly this is very much on the agenda in the UK at the moment. This is a wider question. I mean, Richard Alderman has said that a third of SFO resource is being dedicated, a third of their 300 complements, so 100 people, will be on fraud, overseas corruption. I mean, it seems an extraordinary volume of resource to be targeting. Would you say, as it's an unfair question perhaps, that that's warranted in the volume of fraud which is already going on within the UK? I mean, it's a huge sledgehammer.
I mean, I think it's the very fact that they've got their own distinct police section dealing with it is going to mean that there is a considerable volume of cases and resources going into overseas corruption. It shows that the government's keen on tackling the problem. But I agree that the SFO is going to have less resources next year than it has this year. How it's going to deal with resourcing other fraud investigations is going to be interesting, because even when you look at Richard Alderman's latest document on self-reporting, it deals with corruption cases. It doesn't deal with general fraud issues that might arise in organisations. So we know where the emphasis is, and we'll have to see how he uses his limited resources next year to deal with cases in general, and which cases outside of the corruption arena he feels are ones that he wants to investigate.
And the other point, I mean, I think the Financial Times looked at it recently. They said actually the number of companies so far who've come forward to self-report has been actually very, very low. It's not actually been a great rush to the door to say. Yeah. So presumably there are certain elements which are stopping corporates. I mean, one thing which occurs to me is that, you come forward, even Balfour Beatty has done a deal, has done a civil settlement, but that doesn't preclude, say, the US authorities taking action against them. I mean, they've flagged that up, haven't they?
It's a very difficult decision in this country. If you have a UK client who becomes aware of an issue, as to whether they self-report, and each case would have to be looked on its very peculiar facts to decide whether to do it. It's much harder here than perhaps in the United States because of the difficulties that the SFO has had to successfully prosecute in the past, and its use of its resources. Because if you're going to sell self-reporting to a client, then they have to understand there's a benefit in doing so. If you've got directors who generally come forward and want to sort a problem out, and you advise them to self-report, what happens if they are investigated, prosecuted and imprisoned as a result of that? So you have to weigh it up very, very carefully, as opposed to that firm going forward and being treated leniently and being treated in a way that prevents a costly and lengthy investigation. It's a lot to weigh up in the balance. But how do you sell it? When you have had such bad publicity in relation to the SFO in the past? Because people want to know that there's an organisation with teeth that's going to get them if they're going to do it, which is why companies don't have a problem in going forward to the SEC and the Department of Justice in the United States, because those organisations do have teeth. But coming back to your point, if you do self-report, then yes, the Serious Fraud Office will share information with other organisations. There's a much closer relationship between them and other jurisdictions, and it does raise issues about whether, if there was, say, a large link to the United States, that you wouldn't lose the investigation to the FBI and then to the Department of Justice and find people being extradited back to the United States.